Dustin Paschal here with Simon Paschal Says, back after a long absence between the holidays and some busy work. We kind of fell behind a little bit on the videos, so we are back and hopefully going to be a little more regular on getting you the videos that you want to see. With that in mind, if there's ever a topic or a question or anything you might have, drop us a line on Facebook or Twitter or shoot us an email or something, and we will try to answer that question and get it for you on video for our little video series here. But today what I thought I'd talk about or come back to you with is kind of an FMLA discussion, or at least a piece of an FMLA discussion. And this kind of relates to a blog that we did. It's a written blog on our website about the FMLA key employee exemption. So if you want to read about it, if you're more of a visual learner, you can go look at it on our blog. But in general, under the FMLA, workers are eligible for 12 weeks of leave in a 12-month period for serious medical conditions and after the birth of a child, and some other military-related things. So that's kind of the basics on the FMLA. It applies to employers who have 50 employees within a 75-mile radius. And what the FMLA gives those employees is job protection, basically unpaid leave, and that they can return to their job upon completing that leave. But now there is a limited exception to that FMLA that we all know that provides adjusts the job security protection when it relates to key employees. So essentially what the FMLA does is define a key employee as a worker who is among the top 10% of the employer's highest paid employees within that 75-mile radius. And now, what the exception says is if that key employee's absence would result in grievous and substantial economic injury, that's the language the FMLA uses, then the employer can inform the employee that their job will not necessarily be protected during the leave. Now, the rules require that an employer notify the worker in writing at the time that the leave is requested that the worker qualifies as a key employee and that the worker might be denied that reinstatement. The employer still has to provide the leave. This just affects the reinstatement provision. Now, there may be some state laws out there that dictate differently than the FMLA. We're talking just FMLA, but Texas specifically does not have its own equivalent to the FMLA, and so Texas law is going to follow the FMLA leave in this arena. So if you're a Texas employer, you can kind of go by the rules here that we've outlined in this video, but if you have employees in other states or you're an employer in other states, you should check to make sure that those states don't have an equivalent law. So there's a little tip for you there on the key employee exception or exemption to the FMLA. So thanks for joining us today. Tune in next time for Simon Paschal Says.